This is HFO's Multifamily Marketwatch, presented by Pacific Exteriors Northwest, a contractor specializing in siding and exterior envelopes, delivering exceptional quality and service for over 30 years. By Aprio, combining DeLapp's Pacific Northwest experience with Aprio's global resources to offer unparalleled tax, wealth management, and advisory services for real estate owners. And by Kennedy Restoration, helping residential and business owners recover from fire, water, mold, and storm damage.
Welcome back to Multifamily Market Watch. I'm Greg Frick, partner with HFO Investment Real Estate. Today we have with us Kristine Pizzuti. She is VP and Underwriting Counsel for First American Title Company, one of the bigger title companies in the nation and very prominent here. So thank you for coming to speak to our audience.
You're welcome.
Not that we talk a lot about this, but we have started to see some of this, and we thought maybe have you come and talk about receiverships and distressed assets. We don't see a lot of it like some other submarkets or other markets within the United States, but it'd be good for people to know. So maybe can I give it, what exactly is a receivership for people that aren't familiar with that term?
Sure. So a receivership is a legal process where a party, an aggrieved party, goes to a court and petitions to have a receiver appointed to take control of assets. And we are seeing a lot more of them in Oregon in general since 2018, and definitely a lot more of them since COVID and distressed assets that have come out of as a result of that, mostly in office and some in hospitality.
And what point is it a foreclosure? Is it part of the foreclosure process into receivership? Are they tied together? How does, like I said, we don't have a lot of them. I mean, we've had more than normal, but we're not looking like, where servicers are taking a bunch of things over right here, in the Southeast or things like that. So it's kind of explain how that's related between the foreclosure and a receivership.
Yeah. So in most contracts that have to do with debt or lots of business arrangements where you have a party that can become insecure, like a lender, they have lots of remedies that are available to them. And a receivership has almost always been one of those remedies that are available to lenders and parties just in normal contracts. But mostly we're seeing it with lenders, so we'll kind of use that as our reference point. But so they'll have a list of remedies that are available to them. And there is, they can force someone into bankruptcy. They can do foreclosure. They can do non-judicial foreclosure. They can sue them in court with contract disputes. There's lots of remedies. And receivership has always been one of those remedies for the most part. But people haven't used it because it was case law dependent. And depending on the case law in a state, you didn't know what you were going to get when you did a receivership. So in 2017, the Oregon legislature did there was introduced a Uniform Receivership Statute in Oregon, and in 2018 it took effect.
So that's why you saw it's not necessarily a market; it was a new law coming from the state.
But it's always been here.
Right, it's always been here, but
now it's codified. And now judges have some authority and some guidance from the legislature about what they want a receivership to look like.
So less uncertainty for somebody bringing in the receivership is how the court's going to look at it.
Exactly. And it's a uniform law, so it's been enacted in lots of states, and Oregon is one of those states. And then there's, and the reason that it became more common and that people wanted, creditors wanted more, and other aggrieved parties wanted more control in the situation, or less uncertainty more than control, is because in the Great Recession, banks ended up doing foreclosure processes and things like that, and they ended up owning all these assets they didn't want to own because they're in the business of lending, not owning and operating, and then had to get rid of those assets and things like that. So the receivership statutes have helped add another, quiver in their arsenal of remedies that they have.
Join the HFO community and get weekly multifamily intel. Click to subscribe.
So are they able to come and bring a receivership in as in lieu of doing a foreclosure?
They can
go beforehand. Is that the idea?
They can do. They do it all kinds of ways.
Right.
So we've seen them where they are coming in ahead of a foreclosure. There are foreclosures pending where we've seen a receivership instituted at the same time, so that they're just kind of maximizing the remedies that are available to them.
And now that there's case law, does the process move faster through the courts because there's a roadmap as to what they can judge on, or?
There is. Some of the practitioners refer to it as a rocket docket because it's faster. They can get faster relief, and a lot. But there has always been case law. But now there's a statute to make it a little bit more clear, and there's some provisions in the statute that make it easier to deal with liens and, the relative priority of liens on properties. And so a lot of lenders are, bringing a receivership proceeding as part of their process of, seeking their remedies.
And then so I'm thinking the burden of proof is on, let's say it's the lender doing this. What's the required to get appointed a receiver? I mean, what do they got to prove to the state?
Well, so a receivership is not going to be appointed lightly. There isn't a standard of proof in the statute, but there is case law, and there is a case in Oregon, I think prior to the receivership statute, that called it a harsh remedy. Because, you're taking, a receiver is coming in, an independent third party, and taking control of an asset that's owned by someone else. Right. That's a big deal. Yeah. And so it's considered an equitable remedy. And so the court is going to weigh all of the relative harms and all the relative priorities of all the aggrieved parties, and then they're going to appoint somebody to take control of it. If they do, they're not always successful.
So sometimes they could go in and ask for a receivership, and they may not get that right.
And they may go in and ask for a receivership and ask for a specific receiver, and the court doesn't have to appoint who they ask for. And the party who the receivership proceeding is, who is responding to that, also has the ability to come in and present their evidence and their who they think they are generally going to object, but not always. They don't always object. Sometimes receiverships get appointed just lickety-split. Okay. But other times, if there's an objection, and then they're going to bring in their experts, and they're going to do, they're going to try to get their receiver or their version of the receiver appointed. The receiver has to be an independent third party, though. So
not related to either side.
Right. Correct. Right. Correct. And so that's usually somebody who, they will look at the situation and determine what kind of receiver makes the most sense in the instance with respect to the asset. Is it a workout person? Is the asset being mismanaged? Is there waste? That kind of stuff. And that's how a court is going to determine who the receiver is.
And does the court have like a list of receivers they typically go to based on the situation? I really don't know. I think it's up to, in our judicial system, it's usually up to the parties to bring their list. Okay. That's kind of the common law way of doing things versus like in other countries, a judge would have a list. In civil law countries, they do that. Okay. And then once the receiver, say, gets control, do they have full control? Can they, sell the property? Do they have to go back to the court, to the judge for certain things? How does that all work?
Well, they take control of the property, and then they usually and prudently get court orders for anything that they do. And somebody who's, if they decide they're going to sell the property, they will have a court order telling them they can do that. They can get it at the get-go. That can be a part of the initial receivership order, but most practitioners would, and most buyers would require a court order approving the sale.
Got it.
And that's become custom and practice for sure.
And you said you've seen a big, like in office properties. Are they very contentious? Is it moving through the system faster now that, this is in place?
I think it's kind of all over the place, frankly. There have been receiverships in Oregon where the receiver gets appointed with very little contest, and then there have been other ones that a receiver hasn't been appointed. So it really varies. It varies on the facts and circumstances. And the courts aren't going to appoint a receiver lightly.
Right. It's a pretty big responsibility. And then for, with your company, with, unlike title, are they, if there's other lenders, say there's one lender in first position, we have other lenders in second position, do they have a voice in this, or is it really who brings it to the courts?
Well, everybody who has an interest, anyone who has any kind of interest in the property is going to appear in court and be part of the discussion and the decision. So what happens with the receivership is, it's being brought because there are competing interests, right? And there's perhaps not enough equity based on our market. There's a lot of times there's mechanics liens, there's other liens, there's multiple lenders. And so instead of doing a foreclosure where they're looking at the priority of
First position, second position.
Yeah, they're going to, the court will order the sale of the property free and clear of the liens, but the proceeds of the sale are going to be divided equitably based on the priority of the partners. So basically, it's just switching out the security being the real property because there's not enough to go around. If you're dealing with the loan situation, that's where you're usually seeing
something over too much leverage on the property.
Then the proceeds then get divvied up equitably among all the parties, and the underlying owners can end up with part of that as well.
If there's any left after.
Yeah.
So then your role as a title company is declaring title and making sure anybody that has a claim to that property is notified and.
Yeah. So people will order a litigation guarantee when they're doing a receivership. There's also usually, quite often there's already the foreclosure guarantees and that kind of stuff that are already pending out there and all that. So they have a clear picture of that. But then it really, a big part of what we do when we are underwriting title is obviously we're helping clear title and we're giving everybody a good picture of what's on title. And then we're saying what we're going to require to get those things released. And in a situation like this, the title insurance policy is very helpful because you have now a receiver that does not going to have liability, after the closing of the sale, right? Because the receiver's and just an independent party out there. The seller's not going to be making reps and warranties and all that, so you're not going to be able to go back against the seller. So your title insurance policy is really where you're at. And then the other part of what we do that's really important in these transactions, and we do it in every transaction, but we do it with heightened scrutiny here, is the authority of the party to sell the property. And so we do that on every title insurance policy. It's part of what we do is we make sure that the right parties have signed the documents who can properly convey it. And you'd be surprised that doesn't always happen, and that's why there are title insurance policies and title claims.
Yes, we know, yes.
Yeah, but in the receivership situation, that is, it's an extra set of eyes or many sets of eyes on making sure that all the court documentation and everything is okay and that we're signing off by issuing the policy that the proper party and the receiver has the proper authority to sell the property.
And do you see this more in the commercial, as opposed to like the residential side? Is there a differencing on how lenders are dealing with some of these issues?
Yeah, I really don't know about the residential side of it because I only do commercial. We are seeing, we're seeing all kinds of, we're still seeing some foreclosures and judicial foreclosures and non-judicial foreclosures because there's, the difference there. And then we're seeing receiverships and we're seeing them in tandem too.
Okay, so, going together.
Yeah. And again, I said mostly we're seeing it in office. Haven't seen anything in industrial, not super common in multifamily. At least here. No,
not here. No, sorry. I mean, I've talked to other colleagues in other markets, and their whole business plan is working with servicers who are going to be taking properties back. And I'll say even coming in the Great, we just don't have a lot. We had a few here and there. It was very owner specific or property specific, management or things like that. But there wasn't. Hey, one lender's got 60 buildings that are all coming back. We just didn't have a lot of that here. So And then that's interesting on the, judicial versus non-judicial foreclosure. Has there been an uptick in those as well?
Well, I would say that seems to have slowed down a little bit. But since COVID, we've definitely done lots of reports for foreclosures.
For foreclosures,
yeah,
moving
trustee
forward.
sale guarantees, what they're called. Yeah.
And on a receivership, is that more to use when there's like things that need to be done at the property? We need to take control and try to get it, ready for disposition, or why would the lender choose that route versus going like it's just a straight foreclosure, just easier to?
Well, they won't go into title if they do the receivership. And so I think that's a big motivator. I mean, I don't work for a lender.
But it keeps it off their, right. Right.
They don't end up with it in that it's efficient to have a third party selling the property. Yeah, so I think that's the motivation for the lender.
Right.
And that it's faster and there's more flexibility, than following the foreclosure statutes. And the foreclosures can take a really long time too, of course.
They can get stretched out, especially if there's contesting or things like that. So,
and they definitely, it just seems like the practitioners in Oregon that practice in creditors' rights stuff, they're using everything that's available to them now, and you are seeing a lot more. You just didn't see a lot of receiverships before.
No,
you
very
really
rare,
didn't.
Yeah.
And now, I can just in, around our building, I can think of 4 or 5 buildings that are in receivership in downtown Portland.
We saw some involved more on the estate side, the planning side, where there was, there was disagreement about who was controlling the family side, and they had to hire a third party receiver to come deal with what's going. And so we've seen some of that, but not a lot on with the lender driving it. So
you do see it when you have, it's definitely not limited to lenders. You can have people who are a member of an LLC that feel aggrieved and they have the same remedies. There are remedies in their operating agreement, which can sometimes include appointing a receiver or other equitable remedies, and then somebody can bring a claim, in court and try to get a receiver appointed if the family disagrees or other members disagree about how it's being operated.
Well, thank you for taking the time to kind of share this again. A lot. We don't see them a lot, but we hear them, and so I think there's a nuance to it. But again, hopefully we don't see a continued increase. I think maybe multifamily things to be settled out a little bit, but
thank
we'll
goodness.
see. Yeah. So thank you again for taking time to share this with our audience.
Yeah,
we'll see you next time on Multifamily Market Watch. Thank you.
HFO's entire office specializes in multifamily real estate, making us the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Like and subscribe to Multifamily Market Watch videos on YouTube, articles on LinkedIn, and podcasts on all major streaming markets. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information. HFO is a partner of the Global Real Estate Advisor Network.
Love the insights? Tap the like button and click subscribe. It helps us bring more multifamily news straight to you.